What are standard contractual clauses and when do you need to use them? Or maybe, what do we mean by data transfers? These are complex questions and let's look at these questions in this video. Hello, my name is Punit Bhatia and I'm the founder and CEO of company Fit for Privacy. We are data protection experts and we help you with privacy strategy, its implementation and scenario-based training for your staff. Standard contractual clauses, model contractual clauses, GDPR standard contractual clauses, or UK's international data transfer agreements. Whatever you call them, let's understand about these step by step. And to allow you to understand, let's take a scenario. The scenario being you are a company in the UK or EU. You want to get some services from a company outside of your company. It may be a marketing service, it may be an IT support or IT production support services. That means the other company will have access to personal data that your company has. Personal data about your customers, your employees, your staff, or personnel of third parties. Any personal data that this company will have access to. So this is a situation in which data has been transferred. Data transfer means data going outside of your company. Of course, it can also go out of jurisdiction, that is the country itself. But let's talk about the company. So usually you will make a contract and say this is what the other company should do and this is what we will do. And you know from my other video that there is the role of controller and processor. If you do not understand the role of controller or processor, watch my video on data controller and data processor roles. So if you are a data controller or a data processor, you need to engage in a contract that defines what personal data is being processed, what conditions are there, and what can be done with it. But based on the location of this company, there can be 3 or 4 scenarios. Scenario 1 being you are in the same country, that is you are in the same EU country like Belgium, Germany, France, or wherever. In this case, you just make a contract, no more hassles, simple, easy. If you are transferring data within the EU, that is from Germany to France or France to Netherlands, things like that, still okay because you are in the EU. However, if you are going outside of EU, and now I would say also UK, there are 2 scenarios. One, you are in list of adequate countries or non-adequate countries. So a handful of countries have been deemed by European Commission as having adequacy, that is sufficient level of protection as is expected in Europe. Now, why all this protection in Europe, protection outside? Well, the EU GDPR says that when personal data travels outside of EU, the level of protection offered in the EU must be carried out or must be available, applicable in the other region. Now, as many countries do not have similar laws, this adequacy question or protection question comes in. Some of the countries in the world have been deemed as adequate by EU. The UK has similarly its own adequacy decision because now after Brexit, UK makes its own decisions. So there is an adequacy list of EU and adequacy list of UK. Now, if you're going outside this adequacy list, that's where the standard contractual clauses come in. That means if in the same country as EU, within the EU or within adequate countries, simple, just make a contract along with description of what personal data is processed and what is allowed. But when it is outside of EU and outside of adequate countries, that's where standard contractual clauses come in. Of course, there are other means like binding corporate rules if it's the transfer between another entity of your own company, or certification mechanism and other mechanisms like asking the data protection authority. But talking about standard contractual clauses, this is where standard contractual clauses will fit in. So going back to our example, you are a company based in, let's say, France, you are transferring data or to a company in India. The standard contractual clauses will apply because India is neither in EU nor in the adequacy list. So if you are a company in the UK, the same situation will apply because UK adequacy decision also does not include India. But there are many other countries. India is just an example per se. Now, what are these standard contractual clauses that we've been talking of? The standard contractual clauses are, as the name suggests, a set of clauses which are to be put in a contract defined as a standard by the European Commission, so that you or your legal team do not have to define every time, and they are standardized. You just take them, use them, and add it to your contract. Of course, contract needs to have its own standard terms, but this is about data protection obligations and data protection requirements. Now, as the UK has what I call Brexited, the UK has its own version of standard contractual clauses, which is called the IDTA, another acronym that is International Data Transfer Agreements. So if you are a UK company transferring information or data to another non-adequate country, you can rely upon IDTA. So there are 4 versions of standard contractual clauses in the EU: controller to controller, controller to processor, processor to processor, and processor to controller. Based on what the role of your company, use the right one. And if you don't understand the role of controller or processor, in short, controller is the company which determines the means and collection of personal data processing, while the processor is the one who acts on the instruction of controller, that is the contract. Now, standard contractual clauses, why are they so important? Because these contain obligations like who is responsible for data breach notification, who is responsible for the data protection in terms of data subject rights, what technical or security measures are expected. So all that is described in standard contractual clauses. Use them as is very important. Do not change them. Now, continuing with our example, a French company transferring data to an Indian company, you use standard contractual clauses. What if you are a UK company? If you are operating in UK and you want to work with this Indian company, use IDTA. But if you also operate in the EU and the UK and now you are transferring data to India or Philippines, I would say rely on EU standard contractual clauses, because there's one small difference. The one small difference being both EU standard contractual clauses and UK IDTA are almost the same, except there's an article 28 which lays out data processor obligations, and that is differently written in IDTAs. And that's why I usually recommend to my clients to use standard contractual clauses, especially when they are dealing with the EU resident data. Another thing is UK IDTAs are recent. The standard contractual clauses from EU have been in place since 2010. 2021 they've been refreshed. So in my view, the UK IDTA is an unknown commodity, and I don't know how much of acceptance it will have in the international domain. Now, some dates in context of this. If you are a company in the UK and you are signing a contract today, that is say in 2022 but before September 23, what you will do is you will use the new standard contractual clauses or the new clauses by UK. If you have contracts wherein old standard contractual clauses are used, you can continue to use them till 21st of March 2024. Now, why are these dates so complicated? That's how they are. So anything that goes on from 21st of September 2022 should use the new standard contractual clauses or the new IDTA. While all your contracts that have the old standard contractual clauses must replace them with new standard contractual clauses by March 21, 2024. I'm talking about these dates in context of the UK. If you want to know about the dates in context of EU or any other specific situation, do not hesitate to contact me. So let's summarize this. When you engage or work with a third party, that is a company to provide services in which personal data exchange is applicable, data is being transferred and data needs to be protected as if it's in the EU. For that, 3 options. If it's in the same country as an EU country member, no issues. In EU, no issues. In adequate countries, no issues. But as long as it's non-adequate and non-EU country, you need to rely on standard contractual clauses or UK's IDTA. As you do that, it's important to use them as is so that they remain relevant. When you change them, they are not relevant. I hope this video was useful and you learned about standard contractual clauses. I know this is complex, and if you need help, do not hesitate to contact us, and do not just copy and paste standard contractual clauses. Do engage with a legal counsel or a privacy expert like us, and it helps you. For now, I would say thank you so much. If you like this video, please do click like, do comment and share, press the bell icon, and your support matters. For now, have a safe day and keep protecting personal data.